Hello, I'm Belinda Conaway, your Register of Wills for Baltimore City. Welcome to The Will, a show dedicated to informing you, the citizens, about information related to wills and estates. Welcome back to the last of our three-part series with Baltimore City Register of Wills team, Gaines Landsey and Kelvin Richardson.
Thank you.
On this show, we will specifically define and discuss the role of a personal representative. That is the person responsible for settling a deceased person's estate. We will do our best to answer questions about the responsibilities of the personal representative and talk to you about how to choose the best person for the job. We will also give you some examples of what happens when no personal representative has been selected. And join me for my new edition of the Conaway Chronicle, where I share new information about things happening right here in your community. I'm Belinda Conaway, your Register of Wills for Baltimore City. Instead of making your usual New Year's resolutions that fall by the wayside in a few weeks, why not do something that will protect your assets that you've worked so hard for? Write your will today. Be sure to visit us on Facebook at Row Baltimore City or call 410-752-5131. And remember, where there's a will, there's a way. Welcome back, Mr. Landsey and Mr. Richardson.
Thank you.
Thank you both for being here today.
My pleasure.
Before we get started, I want to remind you that we strongly encourage you to call our office first with any questions. We will arm you with valuable information to help minimize the number of visits necessary to complete estate business. You may reach the Register of Wills office for Baltimore City at 410-752-5131. Helpful information, checklists, and forms are also available on our website, www.registers.maryland.gov. You can also reach us on Facebook at Row Baltimore City. So as we have said before, a will is like a roadmap for the distribution of your assets. It is a legal declaration of a person's intentions and desires as to whom he or she desires to carry out his or her last wishes, and by specifying how these assets should be distributed. A personal representative, also known as an executor, is the person responsible for settling a deceased person's estate to ensure that those last wishes are carried out. All estates require a personal representative to serve as an executor in order to distribute assets, file the proper paperwork in a timely manner, and ultimately be responsible for the estate itself. The personal representative is named in your will, and if you don't have a will, the Register of Wills or the Orphans Court will appoint a personal representative to your estate. The duties of a personal representative, or the PR, include collecting, appraising, distributing assets, paying taxes, and settling debts owed by the deceased. The PR is legally obligated to act in the interests of the deceased, following the wishes expressed in the decedent's will. Any U.S. citizen over the age of 18 who hasn't been convicted of a felony can be named the personal representative of a will. Some people choose a lawyer or an accountant because of their expertise. Others choose a spouse, adult child, relative, or friend, especially if the estate is small. When choosing a personal representative, think about someone who would be willing to do the job, trustworthy and organized, good at communicating with others, nearby, making it easier to collect mail and locate needed documents, familiar with your financial matters. And be sure to have an alternate PR in mind if the first personal representative is unable to fulfill the duties. Serving as a personal representative is no easy task. You need to really be organized and go through papers, statements, and often pay bills. It can feel like another job during the probate process, But this person becomes the saving grace for the family's assets, helping to ensure that any money and/or property is distributed correctly. As we discussed, the length and complexity of an estate really depends on multiple factors, such as the assets involved, the number of heirs or interested persons, whether or not a bond is needed, and whether everyone involved in the estate signs off on the waiver or not. Other factors are the necessity to run notice in the newspaper and the degree to which the heirs cooperate with the personal representative. But if you organize the papers for a personal representative, hopefully you will have some early conversation with the personal representative, and then the process runs much more smoothly. Whoever is assigned the personal representative in the will, or who comes into our office with the proper paperwork and qualifies to be the PR without a will ultimately secure control over the estate through its duration. However, even those assigned as the personal representative in the will can be disqualified as the estate executor if in fact someone files to have them removed with the orphans court and shows just cause why they can't serve, or if that person has been convicted of fraud, extortion, embezzlement, forgery, perjury, theft, or any other serious crime that reflects adversely on their trustworthiness, and that's by Maryland state law. If none of the immediate family members or heirs want to serve as a personal representative, someone else can become the PR and open and maintain an estate by filing a petition with the orphans court and receiving the permission of the judge. So let's talk about the job of the personal representative. All right, so what are the responsibilities of a personal representative?
Well, the responsibilities of a personal representative are actually pretty cut and dry. They're very basic. The personal representative is the one that has the fiduciary responsibility to make sure that all assets of the deceased are going to be claimed, managed, and at the end of that whole process, distributed. As we've already expressed, there are two types of estates. One's a small estate, currently $50,000 in assets in the deceased's name alone or less. The second is a regular estate, a large estate, assets in the deceased's name alone that are in excess of $50,000. So the personal representative is trying to collect or gather those assets, provide proof of the assets when they come in to open an estate. Again, an asset of the estate is in the deceased's name alone. Could be a vehicle, could be a home, could be stocks, bonds that are not beneficially named or jointly held, and bank accounts primarily are the four major categories. Sometimes IRAs, insurance policies where somebody was a beneficiary but is now deceased as the beneficiary, and there's no one now to receive it. It's still in the person who the personal representative is coming to open the estate for, because there's nobody there to take the money. So that individual now has to report that asset and then bring it into the estate. That's what the PR is trying to do, bring everything into the estate. And by the way, we oftentimes get a client to come in and say, I don't have time to deal with the house, I don't have time to deal with this, all I want to do is make sure the tags don't go off the vehicle and they get towed. That's not how it works. Every asset that is known in the deceased name alone has to come in at the same time, because otherwise we don't know what the value of the estate is going to be.
Correct.
That is the main responsibility that that person has. He also should be keeping all the heirs informed of what's going on. And in particular, the spouse, if she or he is not the actual personal representative, or the children of the deceased, because most people don't understand, including some personal representatives, until we explain it to them. They don't understand that the first person to receive any funds out or any asset division is the person who paid for the funeral. And currently, that's a maximum of $15,000. If the cost of the funeral, cremation, burial, liner, opening the coffin, closing the coffin, came to $15,000, that is due for the person that obligated themselves to that contract.
So basically, you're saying the person that paid for the services
Is considered the largest creditor of the estate. Now, if they only had a cremation and a memorial service, and it's $4,200 or $5,000 or whatever, that becomes the actual amount. The next person to be paid is going to be the surviving spouse, because there is what's called a statutory family allowance. That only applies to two parties. One, the surviving spouse, and two, minor children. If neither one of those exists, then really we're talking about children of the deceased, or then parents, or then brothers and sisters, because that's the order if there is no will. If there's a will, that same rule that I just discussed applies to that named personal representative. And they have a responsibility to do exactly what someone who is the nearest relative has to do, and that is to gather the assets, report them, and try to come up with a distribution at the end. However, Mr. Richardson here can explain that he's going to come in if it's a regular estate. So how about your take on it?
Okay. The personal representative's responsibility under the regular estate is, as you say, collect all the assets of the estate and report them to our agency. Over $50,000 makes that estate asset a valued, probated regular estate. From that point, again, there's an information and inventory report filed. There's a 6 months, I call it a probation period, for the creditors and heirs to come forth and recognize the decedent's death and the establishment of the estate through the Register of Wills.
We get back to the importance of keeping those important documents together so that whoever serves as personal representative knows what the assets are in the estates. Oftentimes people have converted to online access for accounts, and a lot of that information goes to the person's email box, which a personal representative may not have access to. It makes it a lot easier when all of that information is together and accessible if something happens. We were out in the community recently, and one of the things that the person said was they did not want to serve as a personal representative because they did not want to inherit the debt of the decedent. And so that is, we get that a lot, where people think that if I serve as personal representative, then I am now personally responsible for the debts of the decedent. So do you want to address that so people understand? Because that is a question or a statement that comes up often when we're in the community.
You're absolutely right. That comes up regularly.
Yes,
and a lot of people are concerned and actually fearful, because they may have excellent credit and they don't want anything to affect their credit, and they don't want a creditor coming after them for the repayment of that debt. If you did not obligate yourself to that debt and the person is deceased, the thing you want to do is gather as many assets as you can locate, handle the funeral allowance reimbursement, handle the statutory family allowance, which, as we know, is $10,000 to the surviving spouse, and $5,000 to each surviving child. Now, if you add that up, you're already talking about $25,000 to $30,000 if the maximum for the funeral was spent. Many times in a small estate, it's just a bank account for $600. So you're never even going to come close to paying off the person who paid for the funeral. They did it out of the kindness of their heart because they wanted to, as they say oftentimes, put the person away in a very, very good reference, good plane. So there's not going to be an asset there. And the estate is considered insolvent. And as long as the estate is insolvent, that's not going to really make a difference. When they get over $50,000 and organizations like Department of Mental Health and Hygiene, which will come after either small estate or regular estate, then you got a separate issue that I'm sure Mr. Richardson can explain.
Yes, it does become a different issue under regular estate because that means that the estate asset now has grown. It is large. $50,000 or more. We have instances where the estate may be holding, let's say, $175,000, and the personal representatives say, well, I received this letter from the Department of Health and Mental Hygiene saying that I owe them $300,000. My first responsibility is to explain to that personal representative, you are not personally indebted to that debt. You received that letter because you are the personal representative representing and handling the affairs of that estate. It has come to the creditors, and DHMH used at their most ability to check with the Register of Wills through online services. They even have individuals that they have come down there because these records are public knowledge and review the assets of these estates. So they know what these estates are holding, what the values of these estates are. They give these personal representatives time to call them. I always employ them. Call these creditors. Make it known to them that you know that you received this information on this claim against the estate. They know that you are sitting on this asset. This asset, unfortunately, is not yours, but belongs to the estate. That debt belongs to the estate. Pay the debt. Pay the debt and continue on with handling the estate, the affairs of the estate. It's very important that they understand that. No, you are not obligated. Now, if you refuse to pay that, and we have had instances where they would not contact the creditor, would not contact them at all, sufficient amount in the estate to handle the claim, and still try to file an administration account and show distribution to the heirs, personal representatives commission, to themselves, doing a final accounting, and want it to be sent to court. In those instances, I will not send that account to court, even for the court to rule on it, to reject it. I will return that, informing them, because it is my job as an auditor to review that accounting and let them know their errors, that cannot be filed in that manner. You have to address that claim. At that point, if they continue to do that, then the people like departments like DHMH, a state agency, will place a lien on the property. They will directly come at the personal representative themselves because they are holding assets and refusing to handle the claim.
And you make a very good point. I touched on it when I said it's not the debt of the personal representative, but if there is a claim filed against the estate, the better way, I believe, to handle it is to respond to that claimant in writing and let them know what the asset total may possibly be and that you are sure you're not going to locate any more assets. That way, if they do some additional research and see what the person's actual debt situation was, the claimant sometimes will withdraw their claim. Or if you do pay it, make sure that everyone else who's ahead of that claimant is paid first. Again, the largest creditor of the estate is the person who obligated themselves for the funeral costs, cremation, whichever they spent for that, the surviving spouse, and minor children. So once they are all taken care of, it's a fair thing to do. But a lot of people are really just downright good people who want to just take care of all those aspects out of their pocket. Then they want to be reimbursed later, and it may not be there to do that. Or they may have already made distribution, and then a new claim comes in during the same time frame that they're waiting to get some other things taken care of, because that's where an attorney can possibly help an individual understand, don't do that just yet until we resolve some other matters that then tell you what the net value of this estate is. If you still have a mortgage on the property, on the real property, then you're going to deduct that from the value of the property. So if it's valued at $75,000 and the mortgage is at $60,000, the property is only worth $15,000. So that's one of the biggest areas for which personal representatives who have that responsibility kind of don't always touch on it in the same manner, and can possibly create a bigger problem for themselves personally.
Right. So it sounds like whoever you designate to be personal representative needs to be someone who is organized and also diligent, that they'll follow up to make sure that they are spending money the way that they're supposed to, making sure that they don't extend themselves and pay bills or take care of things when there may not be money in the estate to be reimbursed.
Absolutely.
Absolutely.
And as you said, keep an accurate tally of what they spent out of the estate, especially in the regular estate.
Yeah, as you mentioned, it is not an easy task. The person that is interested or being selected or even thinking about becoming a personal representative needs to do research into the responsibilities of a personal representative first before taking on that task, because it can be a bit much for some people. And a lot of times they get into it, they find themselves overwhelmed. I get a lot of questions, I don't want to do this anymore. What can I do to get out of this? You know, then of course I have to advise them to go to our court clerk's office and then do a petition to resign as personal representative of the estate.
But hopefully if everyone has their affairs in order, all of their paperwork together, so that you don't have a lot of assets coming up, you know, that people didn't know about, all that information together available for the personal representative makes it a lot smoother and easier. And also the conversations, because a lot of the contention comes between personal representatives and heirs, and it has to do with communications. But when you make your wishes known ahead of time, that helps. It helps with the family members, and everybody knows what's going to happen, what they're supposed to get. So, you know, you don't have that problem on top of the grieving process.
Exactly.
You know, people like to know communication. Open communication is always better, so people understand what's going on. They know what the assets are. They know what they're, you know, supposed to inherit. And the personal representative has the information so that they can proceed in a timely fashion, and they can claim all assets, and they don't have to keep on running back and forth because, oh, we just got this or we just got that. Years ago, we depended on the mail, and you would know that probably within a 30-day cycle, you would have statements from all of the banks, or you would have the mortgage notices. You know, every now and then you might get a property that only has property tax that's due once a year, but the bulk of the estate, within 30 days you'd have it. Again, with the internet and people having accounts different places and, you know, paperless billing and things like that, the personal representative may not have everything if you don't leave it for them. So just trying to make things easier for the person that is left to handle this business. And also the personal representative understanding the type of responsibility it is, how long it could take, you know, to distribute the final assets and close out the estate. That time varies, and it is a responsibility, and it does take time and patience, you know. And phone calls to the Register of Wills office, 410-752-5131, to ask the questions and get help when needed.
Absolutely.
Okay, so sometimes we have situations where, and we get all kinds of questions. People come into the office. We get calls and we have walk-ins where people say, well, the decedent owned this house and that's not on the inventory. So what kind of examples do you have where maybe a property could be a possession of the decedent but not on the inventory list?
They would file what is called a supplemental inventory. These are assets reported to the Register of Wills after the date of death asset. These are called additional assets, and they are, again, filed through a supplemental inventory. They will come into the Register of Wills, go to our inventory department, and request or sit down and be assisted in bringing that additional asset into the estate.
So when we talk about the personal representative, sometimes there are issues where family members feel like assets are being hidden, and they have questions about that. So let's talk about that. You have an estate that's open, there's already a designated personal representative, but a family member or an heir has questions about the assets or information being withheld. What do they do?
Well, one of the things is a breakdown of communications with personal representative and some of the other heirs, because the personal representative will know some things that the heir does not always know because they're not in the battle at the same time. In other words, if a property was left in what they thought was one person's name alone, and in actuality, either in the will or on the deed, it says that I leave this as a life estate to only one child, not all four, where there'd be 1/4 each, but they leave it to one child and say specifically as joint tenants, not as tenants in common. Then that property doesn't even come into the estate, because even though it didn't say joint tenants initially, the life estate has designated as joint tenancy.
So it passes down
Immediately to the heir. So the other three are now concerned. Well, they have an option. They can petition the court for judicial review. If the court thinks there's some wrongdoing after they review the docket and all the documents, then there'll be a judicial review hearing. If the court thinks that the personal representative has done exactly what they need to do by copy of the deed showing that this property conveyed to them, it's a moot point. But the thing is, we suggest options. We don't tell either the upset heir or the personal representative how to handle something. That's for an attorney.
exactly.
But we can suggest that if you think this is the case and want the judge to look into it, because that is out of our hands. So that's kind of a cut and dry look at what we see on a regular basis, because everybody's inquisitive about Where's my inheritance?
Well, what about this asset or that asset?
Exactly.
And so if there are questions, there's an avenue for people to address that, for heirs to address it. Okay, that's excellent. Good information. We encourage people to have the conversations so that some of this is not as upsetting, you know, that people understand what's going to happen, who's supposed to get what, but more importantly, that it is in writing, in your will, hopefully in safekeeping at the Register of Wills office. You can call us at 410-752-5131, and we will be very happy to give you answers to questions and any information that you need.
You know, I still cannot believe that Prince is gone.
I know, right? And he was so young. He died without a will.
Really? I didn't know that. I think I need to get a will.
I think you're right.
Let's not make the same mistake. Write your will today. Call us, visit us online, or check us out on social media. And remember, where there's a will, there's a way. Welcome to another edition of the Conaway Chronicle. CARE, or the Commission on Aging and Retirement, is operated by the Health Department under the Office of Aging and Care Services. CARE was created in 1973 to advocate for older, retiring Baltimoreans. It developed funding and coordinated programs and services for seniors. Part of CARE's mission is to establish pre-retirement programs that help seniors age with grace, independence, and dignity. CARE is the primary public agency in the city responsible for advocating for and delivering services to our elder citizens, their families, and caregivers in the city of Baltimore. CARE serves as the local voice or advocate for public policy for the benefit of seniors. The agency initiates policies that promote healthy aging in Baltimore. CARE can be reached at the Senior Information and Assistance Call Center at 410-396-2273. The number again is 410-396-2273. I want to again thank my guests, Gaines Landsey and Calvin Richardson, for joining us today, our young leader, and you, the viewers. And a special thanks to the students of the Recording Arts and Media program right here at Frederick Douglass High School for producing our show. Tune in next time, and remember, where there's a will, there's a way.